Incidentally, as I've discussed before, I have this sort of pet theory that the regulation of marijuana is actually invalid under the 18th Amendment, and this is one of those theories that implies that maybe I was smoking my own supply or something. But I do have this legal theory, which I'm not sure anyone's ever actually tried in court. So it might be the most bizarre theory I've ever heard of in my life, but I'm not sure anyone's ever tried it. The 18th Amendment, as I'm sure many of you know, banned alcohol in the United States. Of course, the 21st Amendment would eventually overrule it. But I want to make an argument because I need a way to overturn Wickard, right? I need a way to overturn Wickard, at least as it relates to marijuana, right? So if I can't do it for everything, maybe I can do it for marijuana. And I want to make an argument that the 18th Amendment not only was a substantive decision, it was also what would you say? It was not only the decision on the text, right, to say alcohol is banned. I want to make an argument that the people who proposed and ratified the 18th Amendment implicitly made a legal determination that survives the repeal of the 18th Amendment, incidentally. They made a legal determination that survives the repeal of the 18th Amendment, that the 18th Amendment itself was legally required. I want to make an argument that the 18th Amendment implicitly recognizes that Congress cannot, by a mere bill, ban alcohol. Thus, the 18th Amendment itself is necessary. If they could have just done it by a bill, they would have just done it by a bill. So the 18th Amendment not only is the substance of banning alcohol, it also represents a legal judgment that the amendment itself is required in order to give Congress the power, right? And so even though the substance of the 18th Amendment has been repealed by the 21st Amendment, I'd like to make the legal argument that the underlying legal judgment that the 18th Amendment is legally necessary survives. And if the legal judgment, the 18th Amendment is required to ban alcohol, thus banning alcohol cannot be within the power of Congress to regulate by interstate commerce, because that would be the alternative, right? Why not just ban it through interstate commerce? We can't, says the 18th Amendment implicitly. We can't do that. Thus, we need the 18th Amendment. Okay? And if Congress doesn't have the power to ban the sale of alcohol by mere legislation, according to the legal philosophy underlying the 18th Amendment, then it must be true, says me, it must be true that Congress doesn't have the power to ban, for example, the sale of marijuana. Under the 18th Amendment, the 18th Amendment creates a binding legal interpretation on the Interstate Commerce Clause, right? So I want to argue the 18th Amendment. Basically, what I want to argue is that the 18th Amendment implicitly overturned Wickard v. Filburn, and that legal reality persists despite the 21st Amendment. How do you like them apples? That is my bizarre ass legal theory that I've conjured in the contours of my mind. It's like, how can I get past Wickard v. Filburn? And I'm going to use the 18th Amendment to do it. This is, if you currently work for a national marijuana rights organization and would like someone to propose your bizarre shit legal theory in court, give me a call, because I have ideas. I don't think anyone has ever proposed the idea before. I think it might be a completely novel legal theory. But it's what I got. Okay, moving on.